The third defendant from the 23-24 bushfire season is dealt with by the New South Wales Local Court. I'm a member of the public who observes cases from the courtroom gallery and have been following all the bushfire cases from the Hunter Valley from the 23-24 bushfire season. Two defendants, Adam and David, not their real names, have recently been sentenced at Singleton Local Court. The fourth, Chris, is still before Singleton Local Court. Today, Ben from Singleton has his case heard here at Singleton Local Court. He is charged with 3 counts of the bushfire offence for allegedly lighting 2 fires in August 2023 and 1 fire in October 2023. All the fires were in the Singleton area. The October fire was allegedly lit while Ben was on bail for the previous bushfires. Of the 4 defendants here in the Hunter Valley from the 23-24 bushfire season, Ben is the only defendant I can find who allegedly has reoffended. So I'm interested in following this case to see if we can get any insights into the reoffending aspect of the bushfire offence. I will just mention Ben has another case being heard here today. This relates to taking intimate images without a person's consent. However, I'm just going to discuss the bushfire case. I attend Singleton Local Court in September 2024 to listen to Ben's hearing. There are only 6 cases on the list at Singleton on this day. I'm the only one sitting in the gallery where the few defendants come and go. The DPP are here and will be prosecuting rather than the local Singleton police prosecutor. Remember, we are at the local court, so the jurisdictional limit of 2 years jail applies. Therefore, the 21 years maximum imprisonment is not available. They can't sentence for more than 2 years here. However, this case goes very differently to the other bushfire cases. The case starts with the court deciding that Ben is unfit to enter a plea, therefore also unfit to be tried. So Ben won't be asked if he pleads guilty or not guilty. Of course, there's reams of paperwork in front of the magistrate that they are considering when making this decision. The criteria to determine if a person is unfit to be tried is Section 36 of the Mental Health and Cognitive Impairment Forensic Provisions Act 2020, and we're in New South Wales. Basically, it's because the person has a mental health impairment or a cognitive impairment, or both, as well as the person cannot do a number of things listed within the section, such as understand the offence. They may not understand what the legal proceedings are generally about. They may not be able to instruct their solicitor. The reams of paperwork in front of the magistrate is evidence that Ben meets this criteria. So what happens next? Well, this is the part I wish the media were here to report, because I think it's important to discuss how the court deals with Ben's situation. Remember in the previous part when Adam and David were sentenced, I had included comments that people had made about the magistrate's performance. For example, people question why the magistrate didn't do this or that. I think it's a missed opportunity not to look at what the magistrate does here. But there are no media stories about the case in the public domain. The magistrate essentially faces a gap in the law. When a person is unfit to enter a plea and to be tried, generally a permanent stay occurs, meaning Ben will be given immunity from prosecution for these alleged bushfire offences. Basically, that's it. End of the case. Everyone walks away. I think the law isn't requiring the magistrate to do anything more, and it's the magistrate that highlights this in open court. The magistrate raises the fact that ordering a permanent stay isn't going to protect the community. In my opinion, it's the magistrate who's driving for a better outcome rather than just essentially walking away from the situation. And the law doesn't require the magistrate to do this. In my opinion, the magistrate is looking to bridge the gap in the law and put measures in place to protect the community. Therefore, the magistrate goes on to order Ben to be under the care of a doctor. By the way, there's a lot of back and forth about which doctor because the GP in Singleton is retiring. The case gets adjourned to October to sort out which doctor. However, I think it's the magistrate, not necessarily the law, seeking for better outcomes for both Ben and the community to come out of this case. After all, the court is looking for rehabilitation of the defendant and to prevent reoffending, and a few other things, of course. I think Ben's case highlights that a mental health impairment or a cognitive impairment can be associated with the bushfire offence. I also think that Ben's case is a missed opportunity for a public conversation about how the court is following the law in these bushfire cases.